State versus Dwayne Davis, seat 377407, page 6. Hello, Mr. Davis. He's present in custody with Mr. Graskovich and Mr. Brown, and then we have Mr. Bilal and Mr. Giacomo caring for the state. This is on for a motion regarding the evidence obtained from unlawful nighttime search. So, Mr. Brown or Mr. Graskovich, did you want to be heard further on your motion?
I think it's been fully briefed, and I know that Your Honor meticulously prepares for these hearings. To note, the state did not oppose our request for an evidentiary hearing, and I really think that would be the most prudent path to take, given the differings of opinion concerning whether or not bad faith was involved. Obviously, it's our position nothing but bad faith could be inferred from the affidavit that was submitted. That's our primary concern. I think our primary issue is.
Okay, pause right here. This is where things get legally spicy. The defense is arguing that the search happened at night in violation of Nevada's statutory rules. Now here's the twist. This isn't a constitutional violation. That's huge, because when we're not talking about the Fourth Amendment directly, suppression of evidence becomes much harder to win.
So let me jump forward then. I guess if that's the sticking point. This is an argument regarding a non-constitutional violation, so it would be a nighttime clause, which is a statutory construction. What authority is there that allows the court to suppress evidence for a non-constitutional violation under these circumstances?
Well, I think we can look to NRS 179.085, subsection D. It's our position that this warrant was illegally executed.
Sure.
And I believe that the statute, I mean, number one, this is a statutory animal, but number two, that statute allows for the suppression. The cases that were cited, both parties do converge on the point that if bad faith is involved, obviously that's a basis for suppression as well, hence I'm asking for the evidentiary hearing, if the court does not find bad faith based upon the pleadings.
And so what would this evidentiary hearing look like that you're asking for?
We need to have Detective Mogg on the stand. It's our issue that's not necessarily what was presented to the court, but what wasn't that constitutes the bad faith.
And so I guess evidence regarding his stability in the community that you've argued,
Correct.
Evidence regarding the age of his convictions, his age, things like that.
The fact that Detective Mogg had gone to his house and had a conversation with him. Also, the very fact that the justification for this nighttime search creates the very potential danger by executing the warrant at nighttime. That's our concern, and obviously it may be difficult for the court to reach our conclusion absent an evidentiary hearing.
Understood. State, what's your position regarding the evidentiary hearing?
My position is there's no fact that they can establish before this court which would result in you issuing an order of suppression. And here's why, and that's why in their reply they take exception to our exhibits that we supply to the court. The suggestion is well, if you told the magistrate he had survived cancer, she wouldn't have issued the nighttime clause. You and I both know that's not correct, but we also provided you, hey, the detective could have added more.
And here comes the prosecution swinging. Notice what they're doing. They're reframing the issue. Instead of debating what was left out of the affidavit, they're asking, would any of it have changed a magistrate's mind? That's a powerful move.
More about his dangerousness as well. The fact that he makes the threat to Mike Tyson with the gun movement in videos around the time period that it happened. Their other argument is, oh, well, he only said he was arrested as an ex-felon. Well, it turns out he actually was convicted of possession of a firearm and received a 16-month sentence. There isn't any fact they could put before this court in an evidentiary hearing that would in any way change the analysis of the deference given to the judge. Is there any fact they could establish that a court wouldn't issue a nighttime clause? And look, you're a magistrate that signs these all the time. And their argument is that there's only 3 lines within this long affidavit that justifies the nighttime clause. And that's not the way you look at this. It's a holistic approach to this. You're talking about a homicide investigation involving very violent gangs. Yes, maybe 27 years old, but there's nothing in that 27 years that changes the analysis of whether or not a nighttime clause. Now they say they talked to Mr. Davis through, Detective Mogg talked to him through a steel door. What's relevant about that? Mr. Davis doesn't identify himself, denies being Mr. Davis. The fact that Detective Mogg knows it's Davis But also, he refuses to open a security door, and that's one of the things that he lists, that there's a security door that we may have to breach in order to get inside this house. What's relevant about that is more need for SWAT to execute the warrant. But here we have a situation where no magistrate would have ever denied a nighttime clause in this jurisdiction for a homicide suspect's house being searched by SWAT. That alone would have justified the clause, and it was her deference that you have to give the magistrate deference to suggest that they could prove any fact from anything that they've submitted to this court would change the analysis. It's just they haven't come up with any particular fact. They're saying Detective Mogg failed to provide certain information. Sure, in any affidavit you can't describe every single fact that's true, but nothing that he failed to describe that they've raised would change the analysis or change the determination of the magistrate. So I suggest the motion should just be denied outright.
Okay, Mr. Graskovich, you've sort of indicated that without a hearing, obviously getting to bad faith would be difficult for defense. Mr. Giacomo is saying there is no way to establish bad faith, even with what you're saying is, if what you're saying is necessarily true, that still doesn't get you there.
Well, there's reference made to the prior drug conviction, but then the fact that it's over 25 years old is omitted. What do you do with that? I mean, this idea of, for officer safety, the nighttime clause, and again, we're assuming, the issue concerning dangerousness is kind of a holistic approach, and what the detective chose to include and chose to exclude is indicative of a bad faith. We need to address that. In the large part, in the state's opposition, they supplement the record. So they're wanting the court to rely upon matters that were not contained within that affidavit. We're asking the court to do the same thing by way of evidentiary. We're talking to one witness.
Here, the defendant has not demonstrated that the magistrate abused their discretion in authorizing the nighttime service clause under NRS 179.0456D under Sanchez v. State, 103 Nevada 166, page 169 from 1987. A finding of reasonable necessity is reviewed for abuse of discretion. The affidavit provides a sufficient basis for the magistrate's good cause determination.
And just like that, motion denied. The judge leans heavily on two key legal principles. First, abuse of discretion, meaning the magistrate's decision stands unless it was clearly unreasonable. Second, the standard from Franks versus Delaware, which requires proof that officers intentionally or recklessly misled the court.
When I look at the fact that this is a homicide investigation, there is the anticipated presence of the suspect with a prior violent felony and a firearm history, as well as a steel door being present, which is not something common that officers necessarily encourage. The officer and public safety concerns do exist. The defendant's omission arguments do not establish a showing of intentional or reckless misconduct required under Franks versus Delaware. They also don't show that the inclusion of the omitted facts would have defeated the good cause finding. The warrant was executed pursuant to judicial authorization. There's no showing of bad faith, and so suppression is not warranted here. The motion is denied. States prepare the order.
Thank you.
All right. Regarding this as a status check trial readiness, my understanding is that there may be, we may need to readdress the court date, the trial date. But we do have a June 9th status check trial readiness. Do you want to do it at that time, or did you want to set a different date?
Let's do it earlier. I know that we had a discussion with all parties concerning potential dates close in time to current trial setting.
Okay.
Could we set this 2 weeks?
All right, we will vacate the 6/9/26 status check trial readiness and instead set it for status check trial readiness in 2 weeks. That date will be
March 3rd at 9 a.m.
Just we do 3 weeks just to make sure the prison can bring Mr. Davis back.
We'll do 3 weeks. That date will be
March 10th at 9 a.m.
all right. Thank you, everyone.
Thank you.